Perhaps you could begin, or should we wait? We have about 1, 2, 3, 4, 5, 6, 7, 8, 9, I think. I think we could begin. Okay, so tonight we're going to be discussing the Week 6 topic on legislative scope and purpose. And so by covering this topic, we're kind of becoming more up to date with the university's calendar. And to make sure that we actually have a session as well for the revision, I will make sure to hold an extra session towards the end of the term for the purpose of having a revision. And please note as well that we don't really have a week 12 topic because week 12 is meant to be devoted for a revision. So we will have sufficient time actually to have a revision for this course. Now, before we discuss the topic on legislative scope and purpose, hold on, is it there? Okay. Before we discuss this, would there be anything that you may want to raise or any questions that you might have? If you want to say something, just turn on your mic or write something in the chat box.
Manjo, I'll kick it off.
Yep.
It's the same question as always. Are you going to start giving us some hints towards the exam shortly?
Hints? Probably not. Well, it may become evident. Well, the one thing that you should bear in mind is that in terms of the final written assessment, a lot of the questions in the final written assessment will actually will probably take off from much of the tutorial discussion questions. So I will be preparing some scenarios which will be quite similar to those that are in the tutorial questions. So the purpose of this is that we actually end up building on what we learned from the tutorial sessions. So if you carefully go through all the tutorial sessions and make sure that you engage with them by reading the suggested answers as well as getting involved in the Zoom tutorials, then you will find the online assessment to be quite familiar in terms of the questions that are being asked. So I will avoid asking questions that are kind of like questions that we haven't really discussed. So I will make sure that there's something that would have initially been covered in our tutorial questions and the tutorial sessions.
Okay, that's great. Thank you. Now, the other thing too, should we revise all the cases we may or may not read about, or would you be comfortable posting a list of preferred cases, what we really should know, so to speak?
I will not be coming up with a list of important cases that could appear in that will most likely be relevant in the final written assessment. It will be sufficient, though, that I will say that most of the final written assessment questions will actually be based on the tutorial questions that we have. But beyond that, I won't be coming up with a list of cases that you should really dig deep into.
Okay, thank you.
Okay. Anything else? Would there be any other questions that anyone might have?
Kendra,
Yes. Yes?
Will the take-home paper be a legal memo similar to our assignment?
No. This time it will be something that you will often encounter in a final written exam, in the sense that there will most likely be about 5 problem-based questions, which are not necessarily related to each other. So unlike the legal memorandum, where I think a lot of the questions revolved around a common set of facts, the question in the final written assessment will be based on facts that are not related with each other.
So do you mean like 5 mini problem questions?
That's right, yes. So they're going to be
Okay.
mini problem questions. That's right, yes. Would anyone else have any question? None? Okay, so we could probably begin. So for tonight, let's see. So after studying this topic, you should be able to discuss and explain 3 key rules that a decision maker must observe in making a decision or in exercising a statutory authority, namely, that a decision maker must exercise a statutory power according to the purpose for which it was conferred. In exercising a statutory power, a decision maker must not take into account irrelevant considerations. And in exercising a statutory power, a decision maker must take relevant matters into account. So let's begin. Got a problem with my mouse. Okay, hold on. Here. Okay. Got it. So can I ask someone to read the first discussion question for us? Can I have a volunteer, please?
I'll volunteer, Manjo.
That would be Maggie. Thank you, Maggie.
The Commonwealth Development Authority Act, Commonwealth, authorised the Commonwealth Development Authority, CDA, to compulsory purchase or acquire any land necessary to meet the infrastructure needs for new roads and highways of the Commonwealth. At the CDA's Executive Committee meeting on the 16th of May 2013, the CDA's Chief Executive Officer proposed the purchase of a sizable property along Benwick Road that was close to an area where a multi-billion-dollar commercial complex was being developed. He noted that the Benwick Road property is likely to appreciate in value as a result of the commercial development going on in the area. The proposal was approved by the CDA Executive Committee. In June 2013, Greg Harrison received a letter from the CDA stating that it was commencing negotiations with him for the purchase and acquisition of his property along Benwick Road as authorised by the Commonwealth Development Authority Act. Sorry. My throat's a bit raspy tonight. Okay. Greg does not wish to sell his property and has come to you as a solicitor for advice. He brought with him a copy of the 16th of May 2013 Executive Committee meeting of the CDA, advised Greg that there are strong legal grounds to oppose CDA's offer to purchase.
Thank you, Maggie. Can I ask everyone, when you get the chance, to post your answers in the chat box? And then we can start our discussion after that. Sounds like you need a drink, Maggie. Depends on what kind of drink. Peter? Friday night drink. Okay.
Manjo, it's Maggie.
Yes.
Can I just make a comment rather than type because I forgot my mouse?
Yep.
I think a lot of people from reading the Moodle discussions have sort of honed in on the fact that perhaps they are exercising a statutory power which isn't according to the purpose for which it is conferred, and therefore that the gentleman is probably likely to have some success if he actually challenges it. But I was just wondering, on reading the case of...
Maggie, I'm
sorry.
having hearing you. Perhaps you could repeat yourself?
Oh, sorry.
Yeah.
I don't know why. Is that any better?
Yeah, I think so. Yeah.
Maybe I should talk more softly.
Go on. Can you just say it again?
After reading the discussion problem answered on Moodle, it seems to be a consensus that the organisation is probably in exercising statutory power not in accordance with the purpose for which it was conferred. And therein, the gentleman has probably got a good case to challenge the decision. But on reading the case of Municipal Council of Sydney versus Campbell,
Yeah.
which was a council that also had minutes of a meeting included, in fact, a couple, the minutes of the meeting taken into consideration when the court was considering the decision, and because they hadn't actually mentioned anything in the minutes about any improvements or remodelling, there were no plans laid down, they therefore said, well, you're acting not in accordance with the purpose for which the act was conferred. So in this case, would that extra material also need to be considered rather than just on the face of the information that's there?
I've got a problem, really. I could hardly understand what you were saying, Maggie. There seems to be something wrong, at least from my end. I couldn't hear you well.
Okay.
Can somebody help?
Well, I'm here anyway.
Can somebody tell me what it was that Maggie was actually saying? I had a problem hearing what Maggie was saying.
It's Vivian.
Vivian, yes.
I think Maggie was saying that they had more evidence to show that it wasn't for, the primary purpose was not for the profit, but it was for creating more space for their offices or something like that. Is that right, Maggie? Because if it was actually for something that was the purpose of the legislation, then if it wasn't the primary purpose, but like the primary purpose was towards the legislation and then the profit was just a sidekick, that would be still lawful. I think that's what she might be talking about, that case.
Okay. So Maggie, was that in the context of asking a question or giving an answer to the discussion question?
I was trying to give an answer.
Ah, okay.
I'll try and type it.
Yeah, okay. So the answer would be, would somebody wish to add something in addition to what Maggie had said? You could just use the mic. Can somebody use the mic for the purpose of expanding on what Maggie may have already provided earlier?
It's Vivian. I think the purpose of the legislation needs to be the primary purpose behind making the acquisition. And the point would be that if it is the primary purpose, and just because they're going to make money in the long term, a side point, then it'd be valid. But if it is the primary purpose to make profit and not actually be a means to an end for gaining the purpose of the legislation, then it'd be invalid.
Okay, so can you just provide me a direct answer to the question? So what's the answer here? How would you answer the question?
Hi Manjo, it's Libby.
Yes, Libby?
So my answer to the question is that because the Act enables or empowers the CDA to compulsorily purchase land necessary to meet its infrastructure needs for new roads and highways. The fact that they purchase this land with the primary objective of making money in regards to equity in an appreciation and value of the property means that the law regarding the purchase needing to be made in line with the purpose of the Act has not been met. And so then that purchase would likely be deemed to be not upheld by the purpose of the Act, and so it would be an illegal decision.
Okay. So that would actually be the correct answer there. Let's just see. Okay, I'm going to go back to what Libby said. I'm just going to pick up something that was stated here by Peter, and then we'll discuss this further. So from Peter, if the purpose to acquire the property is for profit, it is for an unauthorized purpose, therefore not a legal action. Okay, good. Okay, so the basic rule, so the answer here would be that there would be strong legal grounds on the part of Greg to oppose CDA's offer to purchase, mainly because the primary reason for the action on the part of the CDA to acquire the property is not in line with the statutory purpose as found in the Commonwealth Development Authority Act. So the purpose of the CDA in seeking to acquire the property was based on its desire to profit from any potential development in the area, which is not one of the considerations which is authorized under the Act. So in that case, because the reason why the city sought to purchase this property was based on a purpose that is not authorized by the Act, then the decision, therefore, would be ultra vires and unlawful. So that is simple enough. Now, what if just looking at, okay, now, what if when the CDA made the decision, there were actually two motivations behind its decision to acquire this property. One of them was to ensure that the infrastructure needs of the Commonwealth are being met. But at the same time, the CDA was aware of the potential development of that area, which would then lead to potential profits for the CDA, which it could then use to acquire more roads, because then it will have more funds because it can profit from the acquisition of a land that will appreciate at some time. So let me repeat the scenario. Let's assume that the CDA acts on the basis both of the statutory purpose, which was to meet the infrastructure needs for new roads and highways of the Commonwealth, but at the same time, the CDA took into account the fact that there was going to be a likelihood of an appreciation in the value of the land. So if that were the case, what then would your legal advice be to Greg? Okay, so we've got answers here. From Melissa, that would be valid. From Maggie, substantive purpose. From Peter, it comes back to the primary motivation for the decision. Okay. Let's see. So, would it mean, therefore, that if the decision maker can actually show that it was motivated somehow by the statutory purpose, would that then mean that even if its ulterior motive was actually to acquire the land as a speculative activity, would it actually mean, therefore, that the decision would be valid because it can cite the fact that it had actually considered the statutory purpose? Was that clear? So let me repeat. If the decision of the CDA was actually, if the CDA actually had an ulterior motive, and the ulterior motive being that it actually wished to purchase the land as a speculative activity, but actually in the course of making that decision, it also considered the statutory authority, which was to meet the statutory purpose, which was to meet the infrastructure needs for new roads. In that case, what then would be your legal position?
If that was the case, he wouldn't have a leg to stand on, would he?
There would be, in the sense that they would argue that they were simply following the statutory purpose. So there was a statutory purpose which was to acquire lands, but so they cite that as a reason, as a justification, but there is actually an ulterior motive, which is to acquire the land for the purpose of speculation. So there is a leg to stand on because they're complying with a statutory purpose.
Manjo, it's Libby. Hi.
Yes, hi.
So from my understanding of my reading at the moment, it's irrelevant if there are multiple purposes as such, as long as the primary and substantial reason for the decision is in line with the purpose of the Act, then any aside ulterior motive is viewed generally to be irrelevant and unimportant and wouldn't change or the legality of that decision.
Okay, thank you. Any other viewpoints, especially in response to what Libby just said? So Libby is saying that any ulterior motive would be considered irrelevant to the decision, as to taint the decision, for as long as the decision was actually supported by the statutory purpose.
Manjo, I was, in mind, I was looking at sort of along those lines. I just had a note in my answer. The fact that the CEO noted the potential appreciation of the land's asset value does not constitute a substantial ulterior purpose if the primary reasoning for the resumption is for the above-mentioned purposes for the roads and that. And I was looking at Samurai Proprietary Limited Metropolitan Water Sewerage and Drainage Board. So if the main purpose was for the roads, if they had some other ulterior motive, but that wasn't a substantial ulterior motive, if the main purpose was the highways, wouldn't that be, what have I got here? Yeah, that would be like no grounds to oppose it.
Okay. The correct position would be that if a decision maker actually has an ulterior motive in arriving at a decision, notwithstanding the fact that there is actually a leg to stand on, in the sense that the decision maker can actually cite the purpose of the statute as enabling it to act in the way that it did. The fact that an ulterior motive has actually been considered can actually taint the entire decision-making process. The reason being, as stated by the court in the case of Commissioner versus Northern Territory Council, the decision being that a decision maker will not be permitted to achieve indirectly what it cannot achieve directly. So if it cannot be permitted directly, for example, to acquire property because of an ulterior motive, certainly it can't do it indirectly by propping up its decision-making on the basis of the statutory purpose, if that was simply as a subterfuge, as a way of justifying its decision. So the fact that an ulterior motive is actually considered and is an important consideration in arriving at the decision can actually taint the entire decision-making process, even if the decision maker can actually cite the statutory purpose as the primary reason why it arrived at its decision in the first place. So the ulterior motive is not something that is irrelevant. It is something that will strongly be considered by the courts and can taint the entire decision making process.
So, Manjo, in that regard, ulterior motive in comparison with the purpose of the legislation, the empowering legislation, is different to the other two considerations, which is whether the authority has taken into account the substantial considerations that they should be considering, and not having taken into account any considerations that were superfluous or not necessary to be considered, because in both of those second two regards, they're less, they have less effect on the ultimate decision than this particular point. Is that correct?
That's right, Libby. So those are two distinct things. So an ulterior motive or an ulterior consideration is not the same as taking into account an irrelevant consideration which shouldn't be considered. So as far as the ground that invalidates a decision as being one which is based on an ulterior motive, that goes into the question of whether or not the decision was actually based on a statutory authority or a statutory purpose. So when there is an ulterior motive, what vitiates the decision is the fact that the decision was undertaken not based on a statutory authority or a statutory purpose. Now, there is a separate ground, as you correctly pointed out, which is that a decision can also be vitiated or become defective on the basis of the fact that irrelevant considerations were taken into account. Because in this case, the rule is that even if irrelevant considerations were taken into account, for as long as the irrelevant considerations, even if they were considered, were not the primary reason or were not a substantive reason for the decision, the mere fact alone that the decision maker actually considered irrelevant considerations will not make the decision defective. The decision will only become defective if the if the irrelevant consideration was a dominating or actuating reason for the decision. So those are two distinct grounds. So one, when it comes to the decision being based on ulterior motive, that strikes into whether or not the decision was based on a statutory purpose, whereas the other ground, as found in the ADGR Act, looks into whether or not irrelevant considerations were a primary motivation for the decision having been entered into.
Manjo, can I just ask,
Yes.
sorry, if, for this question, if the executive committee saw this property and thought, right, well, that's good, that'd be good to put roads through, if that comment relating to the fact that it's likely to appreciate in value, what if they're noting that was, in other words, saying, well, look, we should get this now for the roads because if we leave it, it's likely to go up in value. So if we buy it now, we save money, rather than them thinking, well, if we get it, we can make money. What if it was the other way?
Jackie, I seem to have a problem with my... I couldn't hear you well. Do you mind saying it again?
Sorry, what if the resumption of the...
Let me try using a headphone, if this will make things better from my end. Okay, Jackie, can you just say it again, please?
Yeah, okay. What if the resumption of the land, if the comments in relation to it appreciating in value, like potentially, what if they were looking at that thinking, well, if we buy this land now, it's likely to appreciate in the future, so if we buy it now, we'll save money? What if they were looking at from, like, that was just a comment they made, not as the reason, do you know what I mean, to make a profit?
Then you look at the circumstances of the decision making. So courts will actually look into the decision making process. So they are likely to look at the records, like the minutes of the meeting. So if it was just one of the things that was discussed. So let's say some were considering the fact that as a speculative activity, it would actually be beneficial to the CDA to purchase the land. But in the end, the main reason for the decision was because they were simply ensuring that such an acquisition would actually meet the statutory purpose for which the CDA was created. Then in that case, the decision would probably be contested for kind of considering an irrelevant consideration. But because the irrelevant consideration was not substantial, it wasn't the primary motive for the decision, then the decision would most likely be upheld. But on the other hand, if the minutes will show that the that there was, so even if the even if the CDA actually said that they were undertaking the acquisition on the basis of the statutory authority, but when you look at the comments of the minutes, they were actually motivated more by a desire to profit from the possible appreciation of the land, then in that case, what you then have is an ulterior motive behind the decision, even if such a decision could actually be justified as being pursued on the basis of a statutory purpose. Because in that case, therefore, the statutory purpose becomes a subterfuge. It becomes a way of just masking the primary motive of the decision maker. So that would vitiate the decision, because in that case, you're dealing with a decision that is not based on a statutory purpose, as opposed to a question of whether or not an irrelevant consideration was a key motivation for the decision of the decision maker in the first place.
Okay, thank you.
Now, one thing, before somebody reuses the mic again, one thing we need to consider, though, is that what typically happens then in relation to, having these kinds of meetings is that oftentimes they will not have proper minutes of the meeting. So on purpose, a lot of the discussions will be off the record. And so that what happens then is that the ones that will likely be supportive of their decision are the ones that will emerge in the minutes of the meeting. So that becomes a problematic scenario for somebody who would wish to challenge a decision of the decision maker.
Manjo, thank you for touching on that, because that was actually my question as to how do you prove an ulterior motive. And in that regard, can you access minutes of any meeting through freedom of information legislation? Or
You could if they are there. So if there are written records, then certainly using freedom of information laws, you can actually access, seek to have copies of the minutes. You can do that. But again, the problem is if the minutes are incomplete, purposely because the decision makers decided to ensure that most of what they said are not found in the minutes, then you have a problem. Because the courts will assume a regularity in the decision-making process. So they cannot assume that, the decision makers were actually dishonest. Or it might not even be a question of dishonesty, because they might simply say that a lot of their discussions are not as important, because in the end, the initial discussions might be preliminary to the decision, so that in the end, what appears then in the minutes may actually be those that they find to be the more substantive reasons for the decision, even if those primary motivators had actually been strongly influenced by some ulterior motives. So that can be a problem. But that would be one way by which decision makers would do it. And it happens often, not just in councils, not just in terms of decisions of the executive, but even in terms of decisions of the cabinet, where purposely they would make sure that a lot of what they discuss wouldn't appear in written form, which could then be subpoenaed in a proper proceeding. So that is part of the problem that we have. Okay. Now, let's just go back to some of the comments here. Let's see. Got a problem with the mouse. Hold on. So I'm just picking up what Vivian said. So this is the comment from Vivian. In theory, the decision maker should not give consideration to non-relevant matters, but the onus is supposed to be the party objecting. So how do they find evidence support the offer? Yeah, so that's their problem. Their job, because they're questioning the legality of the decision, it will be the job of the one challenging the decision to show proof that the decision was based on an ulterior motive, or that irrelevant considerations were actually a primary consideration in the decision-making process.
So, Manjo, in that regard, if you were going to take on a case of this nature, you would be wise to seek access to all of the documents.
Absolutely.
prior and then ascertain whether you actually do have the evidence to prove it or not.
Absolutely, yes. Because even if you suspect strongly that there were ulterior motives, so as we said, we made a distinction between ulterior motives as opposed to irrelevant considerations. So even if you strongly suspect that ulterior motives were actually behind. So again, let's just clarify. So if it is an ulterior motive, there is no requirement that the ulterior motive is the primary or dominating consideration in the decision. So when we speak of an ulterior motive tainting the decision-making process, it is not necessary that the ulterior motive becomes a dominating, actuating reason for the decision. The fact that an ulterior motive strongly supports the decision, that will be enough to taint the decision-making process. Whereas if you speak of an irrelevant consideration, the irrelevant consideration should be one that is a dominating consideration in the decision-making process. Only in that sense, or only in that instance, will the decision become defective. So now, did I answer the question, or did I get sidetracked there?
No, you answered it, but I have another perspective on the question to ask.
Okay.
Which is it possible for an ulterior motive to be strongly implied by a decision? So is it always necessary to have hard black and white evidence of an ulterior motive if the ulterior motive is blatantly obvious in the decision?
So the ulterior motive is blatantly obvious in the decision?
Yes.
What does it mean? It's cited in the decision?
No. Look, one example that is in my mind is so say for example there was legislation in place which required a health service to undertake a management plan to reduce the transmission of communicable diseases and illnesses. And it was quite a broad piece of legislation that just required the initiation of a management plan. And then the management plan that was decided on was wholly and solely focused on vaccination rather than any other equally as effective or beneficial methods of reducing the chances of transmitting communicable diseases. It could be implied by that decision to initiate that as the whole and sole policy that there was an ulterior motive of mandatory vaccination rather than necessarily just reducing the risk of transmission of disease.
Libby, my question, before I answer the question, I have to ask the question of whether or not the consideration to vaccinate was actually one of the statutory purposes. Because remember, an enabling statute can provide for several purposes. So are you suggesting, or in that scenario that you gave me, was vaccination one of the purposes for which the statute was passed in the first place?
No, the purpose of the enabling legislation was to reduce the risk of transmission of disease. And there was
nothing about the need to vaccinate individuals.
No. Vaccination is not mentioned specifically or expressly at all. The requirement is a disease management protocol to be drafted. It doesn't specify how.
Could it be implied?
I mean, it could be implied as part of it, but it certainly is not expressly stated as the only method.
Okay. Yeah. So you're creating a different scenario in that sense, because you're speaking of a legislation which has its express purpose, which was about health management something, and then that same enabling legislation seems to imply the need to actually permit vaccination of individuals. Now, what we need to remember is that as far as the statutory purpose is concerned, a decision of the decision maker can both be authorized on the basis of what the statute expressly provides, as well as what the statute impliedly provides or impliedly authorizes. So there is no requirement that a decision maker is only actuated on the basis, acts solely on the basis of an express provision in the statute. Now,
so Manjo,
hold on, before I go further. Now, so if we have a situation, therefore, where an enabling legislation provides both for express purposes and there are implied purposes, what we have is a scenario where an enabling legislation has multiple statutory purposes. Okay, so we have a scenario, in the scenario you gave me, the assumption is you have a piece of legislation which has multiple purposes. Some of them express, some of them implied. In that case, the rule is different, because if you have multiple purposes behind a statute, it is sufficient for the decision maker to act on one of those statutory purposes. So in fact, the mere fact that one of the actions of the decision maker may seem to be contrary to some of the purposes of the statute will not invalidate the decision of the decision maker, because it is actually possible for a statute, especially one which bears multiple purposes, to have purposes which are actually contradictory to each other. And it will certainly not be the problem for the decision maker to surmount if he can justify his decision on the basis of one of those statutory purposes.
so from that perspective, Manjo,
Yes.
If you had, for example, an individual who had a religious objection to vaccination,
Yes.
and you could point to the anti-discrimination legislation, which expressly states that it is against the law for an employer to discriminate against an employee based on their religious beliefs and practices.
Yes.
Could you then have an argument that a policy and a procedure that ignores the religious beliefs and practices of a certain percentage of employees, while only allowing for one particular point of action when there were others that were available and reasonable within the purpose of the enabling legislation?
Okay, there are two parts to the question that you made, because when you speak, for example, about a decision based on statutory purpose, we're simply asking the question of whether or not the decision was based on a statutory purpose. In other words, when the decision was made, was it authorized by the statute, either expressly or impliedly? Now, the second aspect would be whether or not relevant considerations which should have been considered were actually considered, and whether or not irrelevant considerations which shouldn't have been considered were actually considered. Now, those questions are separate from the question of whether or not, assuming that a decision was actually validly made because it met those three criteria of a lawful decision. Because one, it was authorized by the statute, meaning it's according to the purpose of the statute. Secondly, relevant considerations were considered that ought to have been considered, and the relevant considerations which shouldn't have been considered were not considered. So in that case, the decision, therefore, is valid. But your question actually now relates to the fact that when the decision was applied, which was valid, it seems to go against or violate certain alleged rights of an individual on the basis of some other enabling law. Now, that is altogether a different question, because remember, in our discussion of this topic, we're simply asking whether or not the decision was actually authorized by the statute. Now, its effect later on, assuming that the statute was authorized, assuming that the decision was authorized by statute, if it happens that in implementing that decision, therefore, it seems to violate some other right, that is altogether a different question.
Sorry, I got off track. Thank you. I understand that. Thank you.
Okay.
Sorry.
So let's see now.
Sorry, Manjo.
Yes.
Grant.
Grant, go ahead.
I came in. Sorry, I came in late on all this because I was a bit late.
Yep.
Just a quick question. Until the CDA sells the property on for profit, how do they say the motive was wrong? Because they can always stand by, oh, we're going to build the infrastructure. As in, like Greg, you know how they've approved it, and they've approved to purchase the property to build the infrastructure. If they go ahead and build infrastructure on it, how does Greg's argument stand up that they only bought it to make a profit? Because they're actually building infrastructure on it. But if they passed it on straight away, then his argument stands. So they can always go back to, yes, it may have been in the back of our mind, but ultimately we bought it to build infrastructure, which we did. So you've got no argument, Greg. However,
right.
if in time they sell it on, so how can the decision be made until they build on it or pass it on?
So that scenario is different, because what you're saying then is that the CDA was actually motivated by a desire to build, to meet the infrastructure needs of the Commonwealth, even if it knew that in doing so, it would actually profit by its speculative activity. So on the one hand, the decision was primarily motivated by the need to meet the statutory purpose for which the CDA was created. And in doing so, the CDA was aware that it would actually profit from its decision. That is not an ulterior motive. So the mere fact that, in the process, there seems to have been another possible motivation is not the same as saying that there is an ulterior motive. So in fact, both cases, for example, Brownells Limited versus Ironmongers Wages Board, as well as Municipal Council of City versus Campbell, will have instances in their facts which show that on the one hand, there was a potential to profit which was not authorized. And on the other hand, in doing so, the action of the decision maker was actually based on the statutory purpose. The mere fact that it could be argued that it was the profit-making side which was the primary motivation, even if that could be argued, that will not be enough to taint the decision, for as long as it couldn't be established that was in fact the ulterior motive. That in that case, that simply becomes a secondary consideration. But it was, in other words, it's just something that logically happens as a consequence of the decision maker considering all of these various scenarios. The key question always is, what was the reason for the decision? Was it authorized by the statutory purpose? If the answer is yes, so even if by doing so there is the decision maker ends up doing certain acts which profits it in a way that is not authorized by statute, will not invalidate the decision.
Yeah, okay, thank you. So basically what I'm saying in this question, the executive wanted the property for the infrastructure. How we noted that possibly the multi-billion-dollar development may increase the land. So that's not the reasoning behind it. So Greg's argument goes out the door until they sell it on. That's how I read the question, as that. And he said proposed purchase of the size of along that was close to an area where commercial that was being developed. The property is likely to appreciate in value. Well, he hasn't said, yes, it's going to make a profit, but he still wants to buy it for the infrastructure. Greg's argument.
I think the facts are likely to be read in such a way that the CDA was mainly motivated by the possible appreciation of the value of the land. So looking at the facts, I would suspect that one strong reading of the facts would be that the primary motivation for the acquisition of the land by the CDA was actually because they knew that, or they suspected that the land was going to appreciate in value. So that would be my reading. If that is the case, that is an ulterior motive.
Okay, thanks. I'll work for the CDA and argue against Greg. Thanks.
Okay. So we could probably move on to the final question. Where are we now? Okay. Can I get a volunteer to read discussion question 21 for us?
I'll read it, Manjo. It's
Thank
Catherine.
you, Catherine.
Under the National Business Risk Assessment Agency Act 2012 Commonwealth, the National Business Risk Assessment Agency was created to examine, review and assess business risks to Australia and provide policy recommendations in the area of business risks to the federal government. The Act also empowered the NBRAA to review its statutory mandate, broaden the scope of its purpose and make every regulation necessary or convenient to be prescribed for carrying out or giving effect to this Act. In May 2013, the NBRAA Executive Board, concerned about human rights violations and security threats in Afghanistan, Iraq and Syria, passed the Restricted Commercial and Business Activities Regulations 2013, which imposed huge fines on any Australian business that conducted or engaged in any new business or commercial activity in any of those countries without its prior written authority. The Hotbed Startup Pty Limited sought approval from the NBRAA to sell its products in Syria. When the NBRAA refused to give its approval, the company challenged the agency's legal authority to pass the Restricted Commercial and Business Activities Regulations 2013. In its letter to the company, the NBRAA pointed out that under the National Business Risk Assessment Agency Act 2012 Commonwealth, it had broad and unqualified powers to validly pass the contested regulations. Hotbed Startup Pty Limited has approached you as a solicitor for advice. Advise the company whether it has a legal ground to challenge the decision of the NBRAA.
Thank you, Catherine. Can I ask all of you, if you could, to post your answers in the chat box? And if you're ready, you can also use the mic to answer the question. Okay, so what's the legal ground? So most of you are saying that there is a legal ground to challenge the decision. On what ground can the decision be challenged? Why is it considered ultra vires?
I'll try to answer that.
Yes, B, yes.
Even if an act which purposes have very broad scope and powers, the power is still to be exercised in accordance with the scope and purposes of the enactment, which is its source, according to Shilesky and Minister of Immigration. The purpose of the act, if not expressly and clearly stated, can be construed using the principle of statutory interpretation. In this case, the stated purpose was to examine, review, assess business risk, and provide policy recommendation. Thus, the regulations appear to be made for a purpose that was not authorized for the statute under which it purports to be made. The regulation will be invalid according to RN2He. The Act does not give the NBRAA powers beyond assessing the risk of doing business and providing policy recommendations. They do not involve making regulations restricting the activities of business enterprise, and thus such regulations will be ultra vires and beyond the power of the Act. So Hotbed can seek a judicial review under Section 52C of the ADJR Act, as the regulations requiring permission before selling products in Syria does not lie within the scope and purpose of the NBRAA Act.
Thank you, B. That was very good, very comprehensive, and very accurate. Did you post your answer in our Moodle site? Very good. That was a very good answer. Well done. Well done. So thank you. Now, I have a question though. In the scenario that I gave, the Act also empowered the NBRAA to review its statutory mandate and broaden the scope of its purpose and make every regulation necessary or convenient to be prescribed or carrying out or giving to this effect to this Act. Now, couldn't it be argued, therefore, that when the NBRAA Executive Board so assuming that the NBRAA Executive Board, passed regulations expanding the scope of its purpose, which then included a purpose which was to regulate certain commercial activities, although they were not found in the enabling statute, wouldn't that regulation actually be valid, given the fact that the primary legislation authorizes the NBRAA to broaden the scope of its purpose and, you know, make every regulation necessary? Did everyone get that question?
Sorry, can you repeat that, Manjo, please?
So, if you will notice in the scenario, the Act actually empowered the NBRAA to review its statutory mandate and broaden the scope of its purpose, and also make every regulation necessary or convenient to be prescribed for carrying out or giving effect to this Act. So let's assume that the NBRAA, based on the enabling statute, then passed regulations broadening the scope of its purpose so that it included as one of its purposes the need to regulate commercial and business activities. The question then becomes, would that regulation be deemed invalid if the regulation can in fact be supported by that liberal wording of the enabling law, which permitted the NBRAA to broaden the scope of its purpose?
It'll be valid then, won't it, if it can be covered by the scope and it's got a broad purpose and allows the executive to make their own decisions?
Sorry, what was that again?
It would be valid, wouldn't it, if the regulations had a broad scope and gave the executive the power to make their own decisions?
So essentially the crucial point there is, how then are we meant to interpret that provision, or that phrase, broaden the scope of its purpose? That actually is the legal issue there. Do we interpret that provision as meaning that the NBRAA can broaden the scope of its purpose according to according to however it likes to broaden its scope? Or is there actually a limit to the way that it can broaden the scope of its purpose?
It would need to be reasonable, wouldn't it, in all the circumstances?
Okay, so I think we can agree that we need, so it doesn't mean that because there is that provision that it can broaden the scope of its purpose, it doesn't give a blanket authority to the NBRAA to then, just do whatever it wishes and therefore broaden its mandate. There is a limit. The question is, how then do we determine the scope of what the NBRAA can do, given the fact that there is an expansive provision which seems to authorize that agency to broaden the scope of its purpose? How then do we limit that specific provision there?
Look at the purpose of the Act, the explanatory
Yes.
memorandum, perhaps the title of the Act,
Very
and all
good.
the other
Very
items
good.
that you look at in interpretation.
Very good. So if you pick up the answers in the chat box here, from B, you can use principles of statutory interpretation. From Libby, express or implied purpose of the Act. Look to the title. So you apply rules of statutory interpretation, which means, therefore, that you should look into the express or implied purpose of the Act as a way to limit the way that provision, although it seems to be quite liberal and broad, for the purpose of limiting the application of that specific provision. And then Catherine, not really stealing other people's thought. Okay. Yes, what else? So that's it. Now, what else? Is that all? So assuming that when we read that I'm looking at that phrase, broaden the scope of its purpose. So we agree that even if that phrase seems to be very expansive and unlimited, the rule still is that that phrase should be read down to ensure that it does not go beyond the purpose of the statute, whether impliedly or expressly. And you also look at the title of the statute and perhaps any discussions of the members of parliament when they pass the statute to enable you to interpret what they actually intended. So we agree on that. Now, the question is, would it mean, therefore, that under all circumstances, if the executive authority can rely on a primary legislation, because the primary legislation authorizes it to act in a certain way, does it mean, therefore, that in all circumstances, any executive action or decision which is based on a statute will necessarily have to be lawful? So in other words, is the test of the legality of the statute, of the regulation, based solely on the enabling statute? Or would there be other extraneous limitations on the executive action or decision apart from the enabling statute? Okay, so subject to chapter 2 or subject to tab. Okay, so the rule still is, it is not, so even assuming that the a statute gives wide authority and discretion to a decision maker, and for that reason the decision maker actually acts on the basis of the statute, it would still be possible for the statute to be questioned on the ground that it may violate certain other laws, or it may violate the Constitution. For example, it may be that the enabling legislation is, meaning the law that was passed by Parliament was a law that the Parliament in the first place was not authorized to pass, because we look at, when you look at constitutional law, for example, the basic question that you ask is this a law that the Commonwealth Parliament is permitted to pass? Because the powers of the Commonwealth Parliament are strictly limited to the provisions that are authorized under the Australian Commonwealth Constitution. So in other words, the powers of the Commonwealth of the Commonwealth Parliament are limited to the provisions under the Australian Commonwealth Constitution. It cannot act beyond that authorized by the Australian Commonwealth Constitution. So every time that the Commonwealth Parliament passes a law, the relevant question always is the Commonwealth Parliament acting under one of its heads of power under the Constitution? If not, then that law would be unconstitutional, which means, therefore, that the Commonwealth Parliament can only pass a law that is within the scope of its powers under the Constitution. So if it passes a law that is not within its heads of power, that law, therefore, would be unconstitutional. And so, therefore, it cannot become the basis for any executive regulation that is, or subordinate legislation that is then passed. Because in that case, the executive regulation would be illegal because it springs from a primary legislation that is unconstitutional. And the other thing is, we must remember, is that if you follow the case of A versus Hayden number 2, there are certain constitutional constraints to any actions of the executive, even if it appears to be authorized by legislation. One of them is the principle of the rule of law, or the principle against a violation of democratic rights and freedoms in the absence of an express authorization from statute. So in other words, the courts will not look kindly into an implication that the Commonwealth Parliament intended for individual rights and freedoms to be impliedly violated by a law or a regulation. If there is to be a violation or an infringement or interference with individual rights and freedoms, the courts in A versus Hayden, the High Court in A versus Hayden number 2 clearly pointed out that what you need is an express authorization to that effect. And secondly, even assuming that there is an express authorization to that effect, there are still constraints to the power of the Commonwealth Parliament, in the sense that there is still the notion of the rule of law. And there are obviously constraints to what the Commonwealth Parliament also can do.
Manjo, hi.
Yes. Hi.
Hey, it's Libby. That brings me back to my actual question when I got taken off track with trying to give an example of
Yes.
the situation, which is it likely that the court would look at a particular decision and decide that it's impliable in that decision that there's actually been an ulterior motive at play, even with or without hard evidence, say, for example, minutes of a meeting?
No. Courts will unlikely imply an ulterior motive that vitiates a decision, mainly because there is a rule of statutory interpretation, again, that the courts are meant to imply irregularity of official functions. So courts will in fact imply that decision makers, the executive or government officials acted with a proper purpose. That is a rule of statutory construction.
Thank you.
Now, there is a question here by Vivian. So we should be aware of the Parliament acting beyond their ability? No. So for the purpose of the final written take-home exam, you will not have to know about constitutional law. So you will not have to go into the question of whether or not in the first place the Commonwealth Parliament was acting within its head of power. That will not be something that you need to consider when you do the final written exam. But in the course of having this tutorial, I had to take that into account because what we're trying to make sure is that we fully understand the complexity of each scenario. Okay, any other questions? So the answer here is that there is a ground for the company to challenge the decision of the NBRAA because the enabling statute does not authorize it to actually regulate business and commercial activities. The enabling statute only authorized it to examine, review, and assess business risks. And it does not include the power to regulate commercial and business activities. So therefore, the regulation of the NBRAA is ultra vires for going beyond that authorized by the enabling statute. Okay, any other questions? Anything else? Any comments before we end tonight's session? All good? Okay. So thank you again for joining tonight's session, and it's a Friday. That's all right, Grant. It's a good thing you joined us anyway. So have a good weekend, and it may be a good time at this point to have your drinks. It's a Friday anyway. So thanks everyone, and I'm gonna see you again on Monday. Thank you. Good night. Bye.